Hello, this meeting is called to order. There are 11 members present and a quorum. First item of business is the oath of office. This will be administered by the city clerk, Ms. Holly Walcott.
Good afternoon, everyone, and welcome. My name is Holly Walcott, and I'm the city clerk, and the city clerk will be the presiding officer of this meeting until you have elected your officers. So with that, and in any case, I normally do administer the oaths of office, so if I could all have you rise and raise your prominent hand, please. And repeat after me. I state your name. Do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of California and the Charter of the City of Los Angeles, and that I will faithfully discharge the duties of Commissioner of the City Health Commission according to the best of my ability. You are duly sworn in. Thank you.
We now have item number 2, and that will be an overview and discussion of the commission's structure, purpose, and intent. And I believe that will be presented by the city clerk, the city administrative officer, and the city attorney.
Yes. You should come here. You stay back. It's up to you.
Good evening. I'm Patty Huber. I'm with the Office of the City Administrative Officer. The Health Commission was set up by an initiative ordinance that was adopted by Council that created this 15-member Health Commission. And each council member has appointed one of you in accordance with that ordinance. The initiative ordinance, which I believe the city clerk sent to you with your package, I'll just briefly outline, basically states that one or more commissioners or staff members of the commission, and I will note you have no staff members at the moment, are to attend all meetings, hearings, working sessions, and other events that are held or conducted by any and all governmental bodies, agencies, or entities of the County of Los Angeles that formulate, debate, enact, or implement health policies or actions unless otherwise prohibited by law. So you have a very broad mandate to attend meetings of the county that's relating to anything related to health and the health of city residents. You are also empowered and are required to publish an annual health services plan setting forth health information that includes but is not limited to the health needs of the city, specific goals for improving health in the city, and a strategic plan to achieve those goals. The City Council shall consider and respond to that health services plan in a public meeting of the Commission in which the Commission members and staff would be invited. So essentially you would transmit that to the City Council and they would conduct a public hearing on your health services plan and strategic plan. You are also required to prepare and present a report twice a year evaluating our progress, the city's progress towards meeting the health goals that you've set forth in your health services plan. And then you're also to review on an annual basis a representative sample of health services contracts that have been executed by the county that provide health services in the city. And some of those things that you are evaluating when you review those contracts is the quantity and quality of health services, the competition in the delivery of health services, including maximizing competitive bidding, and the efficiency and cost effectiveness in the delivery of health services. So that's kind of a brief overview of what the ordinance requires you as a commission to do. At this time, there has been no staff assigned to the commission outside of your commission executive assistant, who is charged with scheduling your meetings, doing your committee minutes, and agendizing, doing your agendas and publishing them. one of the reasons I did this overview is when council was looking at, the establishment of this commission, our office did write a report making a recommendation on a minimal level of staff, which council decided not to do at this time. They preferred to set you up and then have you do an evaluation of what your staffing needs might be, and our office said that we would be prepared to work with you on what those staffing needs might be and make a report to council on that. But that's kind of the role that we're going to play for you in your level of work. When we were looking at that initial staffing report, a copy of which the city clerk has and can provide to you just for reference purposes, we did note that we kind of did some very preliminary research. It was a little hard to find some things, so we did what we could. But we've identified, probably a minimum of 8 or 9 county entities that would have meetings that cover the subject area that you're having, and maybe as many as 20. Part of the thing would be looking at the agendas to see, do they have something on that agenda that is related to the formulation, the debate, the enactment, or implementation of health policies? But some of the ones that we note that do exist are, there's the Commission on Alcohol and Other Drugs, Commission on HIV, there's an Emergency Medical Services Commission, Hospitals and Healthcare Delivery, the Mental Health Commission, there's a County Task Force on Nutrition, of course the Public Health Commission, there are mosquito abatement districts, and right now I think all of you have been seeing the warnings about the new type of mosquito that's around, which is clearly a health issue, but hard to know how much those are on agendas that have relevant implementation of policy for you, because we really couldn't find any agendas. It was part of our problem. But there's also the Interagency Council on Child Abuse and Neglect, which also has health implications. The Los Angeles County Children and Families First Commission, the Homeless Services Authority, and then the CEO's office actually has a health and public safety clusters, because you do have health issues in our jails, as well as emergency medical response, all of which again fall under your sort of broad health-related activities. So you're going to kind of have to corral this and figure out how you want to tackle what you've been mandated to do.
So when the ordinance was adopted and became effective, in it, which again Patty says you have in your packet, but each commissioner shall serve a term of 1 year without compensation. And on behalf of myself and the mayor's office and all elected officials and the residents of the city of Los Angeles, we do thank you for your service and your time. We are counting today as your first day of service in that year, so again, thank you. Patty has told you a little bit about the duties. What from the city clerk's side, we're operating currently under Robert Rules of Order, although we'll give you an opportunity under item, I believe, 3 or 4, to ensure that that's the rules that you want to operate under. But for our purposes, 10 members of the commission constitutes a quorum, and 8 votes are required to pass any motion or elect any officers. If there's any questions on item number 2, we'll take them at this time. If not, we'll move on to number 3. Okay, go ahead, Maria.
On item number 3, we have the election of officers, and this will be a vote required. 8 votes will be required to nominate, to pass a nomination.
Okay, so what I'd like to ask each one of you to do, since I forgot to do it up front, is to introduce yourselves so that everybody knows who you are and that you know who each other is, although you might already. But for my purposes, if you wouldn't mind introducing yourself and giving a few words, we'll go in alphabetical order, which I believe starts with you.
Hi, my name is Carolyn Andrus-Taylor. I'm a public health educator and very much interested in the health of the city.
Hi, my name is Irma Avila, and I'm a community health promoter, and too very interested in the problems of my community. Thank you.
Hi, my name is Sal Esparza. I'm a professor of Health Services Management Administration at Cal State Northridge.
My name is John Hisrick, and I'm a retired faculty member of USC School of Medicine and a retired staff person for Councilmember Krikorian, who appointed me to this particular position.
Good evening. My name is Dr. Erica Hawkes, and I am currently the AVP for Government Relations at Ultimate Health Services. Part of that worked for the Obama administration. Part of that worked for LA County Supervisor Gloria Molina and State Senator Martha Scutia. Thank you.
Hello, I'm Andres Jimenez. I'm a family physician in San Pedro. Been there for 27, 28 years. A graduate of USC School of Medicine, and I'm here with Council District 15.
Dr. Howie Mandel, practicing obstetrician gynecologist, and I've dedicated the last 3.5 decades of my life to trying to help poor women and children get access to health care.
Hi, I'm Bill Rosendahl. I used to be a member of the City Council here, and 8 years of that. But prior to that, I was a cable executive and did a television show for 16 years to inform and educate people about the issues of the day. I also, as the operating boss, I took care of my employees and, of course, my constituents, the voters and the citizens of the city of LA. I worked for Bobby Kennedy. I worked for George McGovern. I was a White House appointee to the State Department under Jimmy Carter. I served in the Army for 2 years. My first year as a psychoanalyst in a mental hygiene clinic, because I have a master's in social work. And I spent the second year advising the general at Fort Carson, Colorado, on how we can make the Army, the military, and all the vets more relevant to the community today. All of this has been a great pleasure, and I'm very happy to be on this commission. Thank you.
Hi, I'm Susie Shannon. I work with homeless and low-income communities in Los Angeles, and particularly at the intersection of health, access for folks who are homeless and low-income. And just very excited to be here and to be an appointee of Councilmember Jose Huizar's. And I just look forward to working with everyone, and I think this is an excellent committee and a great group of folks.
Good evening. Matthew Sharp was appointed by 13th District Council Member Mitch O'Farrell. I've been fortunate to spend the last 20 years of my life invested in social justice cause to try and improve unfairness and equity in Los Angeles, using health policy as the primary vehicle to reshape neighborhoods, to bring families together, to give children a better chance. I've been blessed to have the opportunity to work on policy and legislation, to do research and evaluation, to work with enormously inspiring networks of community leaders and partners to accomplish a variety of measurable changes in our communities and neighborhoods. And I'm honored for the opportunity to try and see what we can do together to bring better results to those who deserve a better chance to live healthier lives.
Good evening, everyone. My name is Nicole Vick. I am a resident of Council District 8. I am a 12-year employee of the LA County Department of Public Health. I am a health program analyst there, working primarily in South Los Angeles. I'm also an adjunct professor at Occidental College. I've also taught at Cal State LA, and I also teach online as well.
Excellent. Thank you, everyone. The ordinance itself does not call for a specific structure on how you would like to operate. We would probably recommend that you have at least 2 officers, either a president and a vice president or a chair and vice chair. What I can do is entertain a motion and a second, and then we can vote on the structure that you would like to achieve, and then we can then take nominations for the offices that you choose.
the commission. I'm wondering if we can do a president and 2 vice presidents
That is
for the
fine.
structure, because we're an awfully large commission with 15 commissioners.
Absolutely your call.
Okay.
I introduce a motion to establish a office of president and 2 offices of vice president. Response to Ms. Shannon's suggestion.
I've heard a first and a second. How do you want to take the vote, Maria?
Are there any objections? If not, then we are approving the desire to have a president as well as 2 vice president positions.
Okay, the city attorney advised that we'd like to hear the number of ayes. So if all in favor of that proposition could say aye.
Aye.
Any opposed? Okay, that motion carries.
So we have 11 ayes.
Yeah, 11 ayes, unanimous vote. Okay, so then, starting with the office of president, are there any nominations for the office of president?
To nominate Bill Rosendahl as president of the Health Commission.
Okay, we have a nomination and a motion for Mr. Bill Rosendahl to be the president of this commission. We have a first and a second. Do we want to do a voice vote around the room? Okay, so we're going to ask each member to affirm their vote, unless there's any other nominations. I guess I should have not jumped myself.
Commissioner Andres Taylor, can you please state yes or no for Mr. Rosendahl as
Yes.
vice president? And I'll ask the same question of everyone. So basically what you have to do is say that you're okay with the nomination of Commissioner Rosendahl as president. Commissioner Avila, can you please say yes or no?
Yes.
Commissioner Esparza,
Yes.
Commissioner Griffith,
Not here.
I'm sorry, Commissioner Hisarich,
Yes.
Okay.
Commissioner Hawkes,
Yes.
We'll come back to Commissioner Griffith.
Commissioner Jimenez,
Yep.
Commissioner Mandel,
Yes.
Commissioner Rosendahl,
I'd be honored to serve in that capacity.
Commissioner Shannon,
Yes.
Commissioner Sharp,
Yes.
Commissioner Vick,
Yes.
and I believe Commissioner Griffith is now here.
Commissioner Griffith, the question on the floor is whether or not to elect Commissioner Rosendahl as the president.
Yes, I do.
We have 12 votes for this position. So we now have a president has been elected, and that will be Commissioner Rosendahl.
Before we move to Vice President, we have a question from the city attorney, and that's whether or not you want to differentiate between a first vice president and a second vice president. And the procedural difference is who becomes chair when the president is absent. So do you want to leave them as just both vice president, or do you want to have a first vice president and a second vice president?
A first and a second vice president, and I'd like Susie Shannon to be the first, and I don't know who wants to be second. He wants to be second, and that's a good one too. Unless there's somebody over there, I don't want to get in the middle of a battle.
Vice President.
This is a first for us, so I apologize for any faux pas up front. I'm going to have to stop for a procedural matter. Commissioner Griffith, can you stand and raise your prominent hand, please? I state your name.
John Griffith,
Do solemnly swear
do solemnly swear
that I will support the Constitution of the United States
support the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
and the Charter of the City of Los Angeles,
and the Charter of the City of Los Angeles,
and that I will faithfully discharge the duties
and I faithfully discharge the duties
of Commissioner
of Commissioner,
City Health Commission,
City Health Commission,
according to the best of my ability.
according to the best of my ability.
You're duly sworn in, sir.
thank
Now
you.
we have to retake the vote for president for Commissioner Rosendahl. So, do we have to go all the way around the room or just... Okay, so we'll just add your vote. Okay. Thank you, Brian. Oh, yes, he voted yes. Okay, so then I heard a motion on the floor. I don't know that I heard a second for the establishment of a first vice president and a second vice president. So can we... Okay, so we have had a first and a second. All those in favor, say aye, please.
Aye.
Any opposed? Okay, so we will have the offices of a president, an office of first vice president, and a second vice president. So let's open the nominations, and I believe I heard one from Commissioner Rosendahl of, you said you...
Susie Shannon.
Okay, and then I heard one...
Second.
And then, did you have one as well?
I'd like to nominate Matthew Sharp as either first vice president.
Okay, so we have two nominations for the... yeah, I heard a second. Yes. Didn't I get a second for Sharp? Okay. For both positions, no, give me 1 second. So, okay, so then the next step is what we will do is we will go around the room alphabetically, and your choices are, at this point, Susie Shannon or Matthew Sharp. So I will ask you, as we do the voice vote, to name your selection. It will require 8 votes to establish that person. Oh, excuse me, we have a question.
Are you taking them for both or just one at a time? For first? And
We're just doing first.
So this will be for the first vice president. When I call your name, you're going to state the name of the person that you're voting for. You have 2 nominees, Ms. Susie Shannon and Mr. Matthew Sharp. Commissioner Andres Taylor, who is your vote for?
Commissioner Sharp, please.
Commissioner Avila,
Commissioner of Sharp, too.
Commissioner Esparza,
Susie Shannon, please.
Commissioner Griffith,
Matthew Sharp,
Commissioner Heserich,
Commissioner Shannon,
Commissioner Hawkes,
Commissioner Sharp,
Commissioner Jimenez,
Shannon?
Commissioner Mandel,
Commissioner Shannon, please.
Commissioner Rosendahl,
Shannon, please.
Commissioner Sharp,
Sharp.
Commissioner Vick,
Sharp.
Commissioner Shannon.
Shannon.
We have We have 6 for Commissioner Shannon and 6 for Commissioner Sharp. We need to have 8 votes.
So we have some options. We can take a second voice vote to see if anybody has changed their mind. We can defer the election to the next meeting to give you time to decide. Or we can, if somebody would like to be first and the other person second vice president, I'm looking for options. So what is the pleasure, actually, what is the pleasure of the president?
as a first and second, and I would love to see Susie Shannon as the first and the other gentleman as the second.
Yes, we are.
Okay.
But we didn't get a majority vote. So we right now do not have a first. So we're trying to resolve what we do in that case. So
I'm happy to withdraw my name from the first vice president nominating question and insert it in the second one. I'm happy to defer to the president's suggestion.
Sweet.
So what we're going to do is a re-vote on the first before moving on to the second. Commissioner Sharp has graciously agreed to run as the second vice president. So with that in mind, can we retake the vote for the first vice president position, Maria?
For the first vice president, Commissioner Andres Taylor, and that will be voting for Ms. Shannon.
I beg your pardon?
We're going to take a vote, and this will be for the first vice president, and Ms. Susie Shannon has been nominated.
I vote for Shannon.
Commissioner Avila,
I vote for Shannon.
Commissioner Esparza,
Yes, Shannon.
Commissioner Griffith,
Shannon.
Commissioner Hiserich,
Shannon.
Commissioner Hawkes,
Shannon.
Commissioner Jimenez,
Shannon.
Commissioner Mandel,
Shannon.
Commissioner Rosendahl,
Shannon.
Commissioner Shannon,
Shannon.
Commissioner Sharp, Commissioner Vick.
Shannon.
We have 12 votes.
Okay, so we now have a president and vice president. We'll now move to the second vice president, which we have a nomination and second for Matthew Sharp. Are there any additional names?
Can I nominate myself?
Okay, then we also have a second nomination for Nicole Vick. Do I have a second? Without a second, we will be voting for Matthew Sharp as the second vice president. Maria?
Commissioner Andres Taylor,
Matthew Sharp.
Commissioner Avila,
Matthew Sharp.
Commissioner Esparza,
Mr. Sharp.
Commissioner Griffith,
Matthew Sharp.
Commissioner Hiserich,
Mr. Sharp.
Commissioner Hawkes,
Commissioner Sharp.
Commissioner Jimenez,
Commissioner Sharp.
Commissioner Mandel,
Sharp.
Commissioner Rosendahl,
Sharp.
Commissioner Shannon,
Sharp.
Commissioner Sharp,
Sharp.
Commissioner Vick.
Sharp.
We now have 12 votes for Commissioner Sharp as the second vice president.
Excellent. Mr. Rosendahl or Commissioner Rosendahl, we do invite you to take the center chair if you would like to, although you're fine to stay where you're at. It's really up to you what you'd like to do.
At the moment, I'd like to just sit here.
All right. We will defer to that. The next item on the agenda is the discussion and adoption of procedural rules for the commission. As I mentioned, we would be operating under Robert Rules of Order until such time as you took a different action. If that is the pleasure of the chair and we have a motion, then that's how we will continue to operate. Would you like to continue to operate under Robert's Rules of Order, President Rosendahl?
It seems like the most sensible thing to do.
Okay.
Clarifying question I have to establish that in the neighborhood council setting I serve where we use Robert Rules of Orders, there has been a designated parliamentarian to assist with the movement of the process, particularly to manage the public comment section where it can be contentious if someone exceeds and has a supporting point of view, etc. To separate that from the function of the president is customarily a useful tool to have a parliamentarian selected. I'm not certain if that's applicable in this context or if that's a decision that even needs to be made at this juncture.
You may choose to do that. That's certainly within your purview to do that. You will generally have the city clerk and possibly the city attorney there for you at each meeting. And we generally assist you with that. But if you would like to have a parliamentarian, you're definitely...
It's not necessary,
Also, there is a presentation on the Brown Act, and public comment is one of the issues that's going to be covered under the Brown Act item on your agenda.
Do I need a motion on the operating under, Robert, is that without objection?
I'll move that we accept the Robert Rules of Order.
Okay, we have a first and second recommending the Robert Rules of Orders. All those in favor, please say aye. Aye. Any opposed? Okay, then the only other thing that you don't have to decide today, but you're going to, as far as procedural rules, you may at some point of time want to develop subcommittees, and I will leave that to the president to decide how you would like to do that. You may want to take some time. I don't know if you want to do that today, but I would suggest that you at least defer till after the Brown Act presentation before deciding how to move forward in any other structural changes you'd like to make. Okay. So then our next item on the agenda is the discussion, is item number 5, the discussion and adoption of a regular meeting schedule, day and time. So how, sir, would you like to, do you have any idea on how often you'd like to meet, or what's at least your next meeting date you would like to see?
I don't particularly have one for that. You know, it depends on what day it is and when we would do it. I prefer to work that out with everybody here as to when we want to have our next meeting. But I obviously believe that as we meet, we will make determinations about subcommittees and how we go forward. Unless somebody here has it already in their mind what makes the most sense, I certainly would be open.
Okay, why don't we hold on number 5 and table number 5 and until after the presentation by the city attorney on item number 6, which is the Ralph M. Brown Act. So I'm going to turn the stage, if you will, over to the city attorney.
Well, good evening, new public officials and returning public officials. I'm Curtis Kidder from the City Attorney's Office, and I'm going to run you through a couple of statutory schemes that now apply to you as public officials and to this commission. And the first one's going to be the Ralph M. Brown Act, and then we're going to go over the California Public Records Act. And I have a PowerPoint presentation that I'm going to do, and I will hand out the slides to you so you can follow along. The PowerPoint will also be on the screens in the back. I think they're throughout the chamber. Some of the ground rules on the presentation. Feel free to ask questions. I tend to talk fast. If I'm talking too fast, just let me know and I'll slow it down a little bit. There's a lot of information in the slides. There's actually going to be one primary takeaway from each of the presentations, and I'll note that when we hit those. Otherwise, as I said, these two statutory schemes apply to you and the board, so there is some good and relevant information in here. And as I said, the first one we're going to go through is the Ralph M. Brown Act, and that's Assemblyman Ralph M. Brown up there. He was the Speaker of the Assembly in the late 50s and early 60s. And the Brown Act was enacted in 1951 as the result of a series of investigations done by, excuse me, the San Francisco Chronicle newspaper. And, you know, back in the old days, a lot of government was done in the proverbial smoke-filled back room. So the Brown Act was really California's open open meetings law that was to bring the actions of legislative bodies out from the back room and make it transparent in front of the public. Let's see if I can operate this now. Oh, there we go. Okay, the intent of the Brown Act is that public agencies in this state exist to aid in the conduct of the people's business, and it's the intent of the law that their actions be taken openly and that their deliberations be conducted openly. One of the primary features of the Brown Act is that all meetings of the legislative body of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency. Very important concept now is what exactly is a meeting, and this is directly from the California Government Code. And it's any congregation of a majority of the members of a legislative body at the same time and place to hear, discuss, or deliberate upon any item that is within the subject matter jurisdiction of the legislative body of the local agent or the local agency to which it pertains. So, sort of the key here, as you will note, it's any congregation of a majority of the body, regardless of place or time. It doesn't have to necessarily be within this room or wherever your regular meeting room is going to be, or at the regular hour. If you are meeting, if you're going to, let's say, a barbecue at one of the members' houses, and there's 8 of you in the kitchen having appetizers, and all of a sudden you're talking about health issues, that's a meeting. And if it is a meeting, then it is subject to the notice and agenda requirements of the Brown Act. The Brown Act also applies to the committees of this body, and it also applies to serial meetings of this body, which I'm going to go over in a little bit more depth as we go along here. There's 3 types of meetings under the Brown Act. There's regular meetings, special meetings, and emergency meetings. A regular meeting is defined as scheduled at a set time and place, as you do by an official action of this body, and that was just on your agenda. It doesn't appear that you've set your regular meeting yet, but once you do, then when your regular meetings occur, you have to provide an agenda and notice 72 hours in advance of that meeting. You may occasionally have special meetings. These are occasional and just called as needed, and they're typically used for workshops or on single topics for extended discussion. And for special meetings, those only require 24 hours notice and a posting of an agenda. The third type of meeting is an emergency meeting, and these are typically called following some disaster or catastrophic event. I used to work for the city of Oakland, and we had a number of emergency meetings following the earthquake of 1989 and the Hills Fire of 1991. The only notice that's required for an emergency meeting is telephonic notice to media outlets. You don't have to post an agenda or provide any other notice than that. Okay, now the Brown Act applies to a number of gatherings that you typically wouldn't think constitutes a meeting. The first one is a collective briefing of a majority of the legislative body. So a staff member gets together with 8 of you and goes over items that are coming up on the agenda. Yeah, that's a meeting. Retreats or workshops conducted by the legislative body. A lot of times folks like to take bus tours. And if there's a majority of the members of this body that take a bus tour of Skid Row, for instance, that's a meeting. It needs to be agendized. And also the public gets to attend that. Informal gatherings where business of the agency is discussed. Advisory committees created by formal action of the legislative body. Here's serial meetings again. I'm going to come back to that in a moment. And then the other item again is your standing committees. So if this body does establish standing committees of less than a quorum, those are also subject to the Brown Act requiring notice and agenda requirements. Serial meetings. This is a big takeaway, and so take note. There's 2 types of serial meetings. One is what they call the hub and spoke, where an individual, could be a member of the board or a staff member or any individual, talks with a majority of the board, 8 members individually, and discusses an item of business before the board and with the intent of reaching a consensus or formulating policy. So it doesn't necessarily require that board members directly talk to each other. They can they can talk through an intermediary, and that's called a serial meeting with the hub and spoke variety. The second type of serial meeting is the chain variety, where Commissioner A talks to Commissioner B, and B talks to C, and C to D, and all of a sudden you reach 8, and that's a serial meeting subject to the requirements of the Brown Act. So just be aware of that. It can occur either face-to-face sessions, emails, text messages. Once you reach 8 members of the body, that's a meeting under the Brown Act and would be prohibited unless it's noticed and agendized.
A recurring challenge in the neighborhood council context, which is serial meetings conducted accidentally through email. So if you could illuminate how that is a potential function to avoid.
Yeah, typically the CEO or the general manager will send out an email to the entire group, the entire board, on an item of business or a procedural item, and one of the board members will then reply to that and press the reply to all, and all of a sudden you've got the beginning of a meeting. So yeah, that's exactly, you just have to be aware of it, that any time that the discussion ebbs over into 8 members, that's a serial meeting under the Brown Act, requires notice and agenda requirements, and is otherwise prohibited if you don't. And that's an easy one. That's an easy one to get tripped up on. As we're evolving in this era of media and easier ways of communication, the Brown Act allows for video and audio teleconferencing of meetings. There's a couple of discrete requirements that need to be met in order for that to occur. Let me catch up on the slides here. Yes.
Applies to us because they require 8 is the number that we need to pass an item on this commission.
Yeah, that's a good question, and the Brown Act has its own requirements, and it's going back to that slide 55. Actually says it's any congregation of a majority of the members of a legislative body. So it's a little bit different requirement under the Brown Act than what you have under your rules. So just be aware of that. Okay, so for video and audio teleconferencing, a couple of requirements that need to be followed in order for you to do it. First of all, and this occurs a lot if one of your members is traveling on business and they want to attend the meeting from their hotel room. Well, what you have to do in that instance is you have to put the location of that remote location on your meeting notice. So like on tonight's notice, you've identified this room as the meeting location. If somebody was going to attend from the Marriott in Salt Lake City, you'd have to put that on your notice and on your agenda. And then the person that's staying at the Marriott, not that I'm pushing Marriott as a place to stay, you'd have to allow public access into that member's room, and it has to be ADA accessible, and the public has to be able to participate from that hotel room. The other requirement is you have to have a quorum within the agency's jurisdiction, so there would have to be a quorum of the board located within the city of Los Angeles for this board. And a member can participate remotely. They don't have to be within the jurisdiction of this commission. So if you can meet all those requirements, then you can participate by either a video or audio teleconferencing from a remote location. Question, yes?
Could a commissioner just listen in on the proceedings from a remote without participating? I mean, as if they were just listening.
Well, that's a good question. I mostly deal with city boards and other commissions that involve a lot of politicians, and I've discovered that it's very unusual for politicians not to want to participate in a meeting. So there's sort of a practical issue with that. But there is a provision under the Brown Act that allows commissioners to attend committees of their commission and just observe and not be counted towards the quorum. in that. And I assume that that may also apply to boards and commissions also, that if you're going to just listen in and actually not participate in the meeting, that may also be subject to that exception.
Thank you.
Although I'd want to spend a little more time with that before they render an opinion.
Oh, just a quick note. We are live streaming, audio streaming these meetings, so they are accessible to the public over the internet, and should you find yourself out of town, you would be able to listen to the meeting.
Thank you.
Okay, so we've gone over a litany of items that do constitute meetings under the Brown Act. There's also things that are identified in the Brown Act that do not require agendizing and noticing, and that's obviously individual contacts, meetings of less than a quorum of the body, conferences. A majority of the body could attend a conference as long as you don't sit together and talk about business of the commission. Same thing with community meetings. You can attend meetings of other agencies. Here's your social and ceremonial events. Ad hoc advisory committees. Let me get back to that one. And then just meetings with agency staff. But be aware of the prohibition on serial meetings. And I advise the commissions that I staff that if you do go to ceremonial events or you go to educational events, I just tell them, just try to avoid congregating together, because you get a majority of your body together. What do you all have in common? You all sit on the commission, and that's just a very easy thing to talk about. So I just advise, just don't all sit together if you go to the retreat or to a ceremonial or social event or educational forum. Going back to ad hoc advisory committees, those are a little bit different than your standing committees. Ad hoc committees typically are created to focus on one item, such as it's similar to a task force. And it has to be less than a quorum of the body. It has to be for a limited duration. And once again, the jurisdiction of the committee has to be limited really to one item. And if they meet those requirements, then they're not subject to the notice and agenda requirements of the Brown Act. Okay, jumping ahead to your agenda requirements. So, your meeting agenda for this evening identified the time and location of the meeting. Very good. And then for each item of business that's to come before the commission, you have to identify it or describe it in such a manner that a reasonable person would know whether they want to attend the meeting and address the board on that item. So it's a reasonable person standard. Is the description adequate to inform a person what exactly the board is going to discuss or take action on? The California Attorney General has advised that it can be 20 words or less, but certainly you can make it as long as you want, but it can also be as short as you want, as long as it meets the reasonable person standard. Suppose you want to talk about an item that's not on the agenda. There's just a couple of exceptions under the Brown Act. One is for emergency items. So you've posted your regular meeting agenda 72 hours in advance of the meeting. Then something comes up 48 hours in advance of the meeting, and you want to know, well, how can we get that on the meeting agenda? A couple different ways you can handle it. One way to do it is you can use the special meeting method that the Brown Act allows for that only requires 48 hours notice. And the Los Angeles City Council uses that. They have special meetings kind of within their regular meetings, so that you could then agendize that item within the 48 hours and call it a special meeting, so you could discuss that at the same time or just after the regular meeting of the body. And if it is in fact an emergency item, you can get it on your regular meeting agenda actually at the meeting. It has to meet two requirements. One, it has to have come to the attention of the board or to staff after the meeting agenda was posted, so that's within the 72 hours before the meeting. And that if the board doesn't have the opportunity to discuss the item at that meeting, that there'll be some prejudice to the city by not acting in time. And this, you'll typically see this, or I've seen it in the past, like on grant applications, that for some reason staff just learned that the deadline to apply for the grant is in, whatever, 3 or 4 days, and it has to be approved by the commission. So, they'll bring it to the board, say, yeah, we just discovered this after the agenda was posted, and if we miss the deadline, then we're going to potentially lose out on money coming to the city. So, so if you meet those emergency requirements, you can add that to the agenda at your meeting. Other things that you can discuss at a meeting that don't necessarily have to be on your agenda are brief responses to public comments. So you've got on your agenda this evening, you do have a public comment item. That's item number 8 on your agenda. So a speaker raises an item that piques the interest of some of the commissioners. So anyway, you've got an item of interest that people want to talk about. What the Brown Act allows is a brief response to a public comment or a public question. If it evolves into an extended discussion or a deliberation of the body, then that really should be set over for another meeting and put on your agenda for your next meeting. Also, commendations don't necessarily have to be agendized. These are plaques and commemorative items, what have you, don't necessarily have to be agendized. Next item is internet posting of your agenda. This is a more recent addition to the Brown Act. The government code requires an agency to post its regular agenda on your agency's website if it has one. That's sort of the key. If you fail to post on your website, then any matters taken at the meeting that were not posted on the website are subject to invalidation. So any member of the public could challenge the action taken by the board, and if they prevail, they get an award of attorney's fees, which can be costly. Voting. Just had some votes here earlier this evening. The Brown Act requires that a board must publicly report any action taken and the vote or abstention of each member present. This doesn't necessarily call for a roll call on every item, just so long as the public can identify how each member voted. And it's pretty easy here in the chambers. They have an actual board that identifies the vote of each council member. So that certainly meets that requirement, and you don't have to go through a lengthy roll call on each item. Closed sessions, some closed session votes need to be reported out after the closed session. I'm not sure if this body will actually have closed sessions, but if they do, then any final actions taken in closed session need to be reported out at the conclusion of the closed session. And of course, no secret ballots are allowed. Let's talk about documents that come with your agenda or related to meetings. There has to be an identification on your agenda where documents that are related to agenda items can be picked up. Typically, those are at the clerk's office. Written materials that is provided to the board after the agenda is delivered must be made available to the public at the same time the board or the commission receives the items. Often speakers or at meetings, either public or city staff, provide additional materials, such as I just provided to you, the handouts, the PowerPoints, and those need to be made available to the public as soon as possible following the meeting. Moving ahead to closed sessions, as I said, I'm not sure that this commission will be holding closed sessions. I'll go over these slides fairly quickly. Closed sessions are really an exception to the Brown Act open meeting requirements, so they're construed pretty narrowly by the courts. And there's 6 or 7 or 8 basis for going into closed sessions, and obviously you want to go into closed session to discuss confidential matters that would prejudice the agency if you discuss them out in the open. And some of the obvious ones, of course, are anticipated and pending litigation. You don't want to discuss the agency's strategy or defenses out in the public. Same thing with real property negotiations. You're trying to buy a property or sell a property. You don't want the buyer or seller to know what your position is or what your bottom line is. Same with labor negotiations. There's an exception for public employment. Let's see if we can get there. This includes the appointment and the employment performance evaluations. A lot of times in smaller cities, they do the evaluation of the city manager in closed session. You can also hear items of discipline or dismissal or release of employees in closed session. Related to the appointment of officials, you can do that in closed session. You would report that out as an appointment, but you can't discuss the salary in closed session. That's an item that has to be discussed in open, regular session. Another one that's in vogue now is threat to the security of public buildings or public services. Certainly you don't want the world to know what your police department's telling you about the security of your government buildings. Okay, your items that are going to be in closed session have to be on your meeting agenda also. The Brown Act actually provides safe harbor wording for going into closed session on each of those the allowed closed sessions that we just went over. Typically, your agency counsel should review that description to make sure you're within the safe harbor of the Brown Act. As I previously indicated, certain items in closed session need to be reported out. Who gets to attend closed session? The Attorney General has advised that you really want just the people that are involved in that closed session item to attend the closed session. So in addition to the board, you'd obviously want your attorney or your real property negotiator there. However, other staff who aren't involved in the transaction or don't offer anything in the closed session really shouldn't attend. The closed session discussions are confidential, so the fewer people that have access to that confidential information, the fewer people that can disclose it. And confidential information that is discussed in closed session can't be disclosed to outside third parties without board authorization. I've recently added this slide to the deck of slides in this presentation. It's the problem citizen. So you've got the person who attends your board meeting and who is just loud and threatening and just upsets the board members and the other members of the public, and it makes it difficult to transact a business. So what can you do about it? I've identified 4 things you can do here, and perhaps the most effective is the cease and desist letter from the agency or the commission. That is, you send a letter to the person and you just tell them your conduct is not helpful, and would you please discontinue your offensive conduct. And this is probably effective a good amount of the time, but you know from watching this city's council meetings that you've got a lot of folks who like the focus on them and not necessarily interested in the business of the city council. Moving down sort of the chain of items or actions that the commission could take in trying to control these threatening and loud citizens, you can make an arrest under Penal Code Section 602.1 as for intentional interference with the public's business, but you have to be careful that you're not interfering with their First Amendment rights. So that's sort of a tricky area. There actually has to be interference with the public's right, with the public's business at the meeting in order for an arrest to occur. Another action can be taken is a harassment restraining order under the Code of Civil Procedure, and this is where a person poses a credible threat of violence or serious annoyance serving no legitimate purpose. You don't see that happen too often. And the other one is a workplace violence protective order. This is where the employer actually takes an action to protect their employee from harassment that occurs at a meeting. I haven't seen that one occur too often either. Okay, let's get to the serious stuff. Violations of the Brown Act can be charged as a misdemeanor, but that requires deliberate and intentional violation to deprive the public of access to the meeting or to information. The more common remedy is avoiding of the transaction. So you take something that wasn't on your agenda, or the agenda description wasn't sufficient to allow the reasonable person to come down to your meeting. Anybody, a member of the public, or even the district attorney, could submit a letter to the board identifying what the violation was and demanding a cure within 90 days of that action. And they have to submit this demand to cure letter to the board prior to initiating litigation. The board has then 30 days to cure the violation. So basically it's what you do is a do-over or take a mulligan. So you would re-agendize the matter and do it properly, or your description more accurately reflects the discussion that's going to occur, and then you take or you consider the item at your next board meeting and either reapprove the item or take some other action. And if the board does cure the alleged violation of the Brown Act, then the citizen is prohibited from filing litigation on that item. If the board doesn't cure and the citizen goes ahead and files litigation and prevails, then the plaintiff is entitled to an award of attorney's fees and costs. And it's not unusual in Brown Act cases to have attorney fees in the six-figure range. So that's a pretty severe slap on the wrist. The media also likes to play up violations of the Brown Act. You see them in the LA Times and other newspapers. Not often, but fairly regularly, you'll see that some public body didn't completely follow the requirements of the Brown Act, and they either had to do a do-over or it ended up in Superior Court. So that's a quick walk through the Brown Act. Any questions before we move on to the Public Records Act? Let's see, let me catch up on the slides here. Okay. Public Records Act. This body's also subject to the Public Records Act. They kind of go hand in hand, the Brown Act and the Public Records Act. If a body is subject to the Brown Act, then typically it's also subject to the requirements of the Public Records Act. It was enacted in 1968, so about 17 years after the Brown Act, and it's codified in the California Government Code. For you statute geeks out there, you can look for it there. The general rule on the Public Records Act is that all government documents are public records and subject to disclosure. So that's the general rule. There are numerous exceptions to the Public Records Act, and in preparing for tonight's presentation, I just looked through the California Attorney General's primer on the California Public Records Act, and there are pages and pages and pages of exceptions. There's probably hundreds of exceptions. Hasn't quite swallowed up the general rule, but there are a lot of exceptions. Okay, the overview and purpose of the Public Records Act, very similar to the Brown Act, is you want to have your members of the community having access to the documents, the government's documents. Public records are open to inspection at all times during regular office hours and subject to copying as provided in the Public Records Act. The Public Records Act, like the Brown Act, is to be construed broadly by courts if it furthers the public's right of access, and it's narrowly construed if it limits the right of access. Okay, what is a public record? Obviously, any writing containing information relating to the conduct of the public's business prepared, owned, used, or retained by an agency, regardless of the physical form or characteristics. A writing, once again, a broad definition includes any writing on any form or format. It includes letters, words, pictures, sounds, symbols, any record created regardless of the manner in which it's been stored. As we know, most of our records these days and going forward are held electronically. And of course, the public can get access to records in electronic format also. They just make a public records request for that, and the agency has to provide those records. However, the requester has to bear the cost of producing that copy. So if you download your records onto whatever, a disk or a thumb drive, the requesting party has to pay for not only the medium on which it's provided to them, but also the time that's involved in preparing that copy for them, which is actually different than just regular hard copies. A public entity cannot charge for making copies, but they can charge a per-page fee for the actual copy itself. I believe it's 10 cents. It might have gone up since the last time I looked. computer and electronic records obviously include things like emails, text messages, and any other correspondence that's sent via electronic device. There's a fairly large case pending in front of the California Supreme Court right now. It's been pending for about 6 months, and this is the use of personal electronic devices to conduct your agency's business. In this particular case, members of the San Jose City Council were sending text messages and emails back and forth on their own phone using their own server. The court ruled in that instance that because those records were not prepared, owned, or used or retained by any local agency, that they were not subject to disclosure under the Public Records Act. The court said that members of the City Council are not included in the definition of local agency under the Public Records Act. That case has now been appealed, and as I said, it is pending before the California Supreme Court. A decision should be out shortly, and see how the court looks at that. The appellate court in that case noted the dangers presented by their ruling because it effectively allows the public's business to be conducted over personal electronic devices that are not disclosed to the public. Not very transparent. The court also noted instances that at meetings when officials use their PEDs to have conversations within meetings, those could be public records if in fact they meet the requirements of the Public Records Act. As I said, there's lots of exemptions from disclosure in the Public Records Act, and some of them are pretty obvious. Personal records relating to personal, medical, or similar files that would constitute an unwarranted invasion of personal privacy. Things like employment contracts, however, are public records. Another one, obviously, is the confidential legal advice you get from your attorney. Certainly you don't want that disclosed to the public. Other ones, preliminary drafts, notes, or interagency or intra-agency memoranda that are not retained in the ordinary course of business if the public interest in withholding those records clearly outweighs the public interest in disclosure of those documents. Some of the other exemptions, records pertaining to pending litigation and claims until the litigation or claim has been resolved. Name, credit history of utility usage data, home address, telephone numbers. A relevant one for many board members is records regarding their deliberative process, where the public interest in maintaining the privilege outweighs the public interest in disclosure of the information. This allows board members to gather and make policy decisions without having to disclose how they reach that policy decision. Then there's the catch-all under the Public Records Act that allows you, if it's not an express exclusion, there are what we call this catch-all exemption that still allows you to withhold disclosure of a document. And the test is where the public interest served by not disclosing the record clearly outweighs the public interest served by disclosing the record. So it's a little bit of a weighing, balancing thing. You have to create a record of that, so if in fact you're challenged, you can identify to the court why you did not disclose that document. If you guess wrong and the court requires disclosure, then you're subject to an award of attorney's fees to the person who challenges. Okay, so your agency gets a Public Record Act request. The request need not be in writing. It can be over the phone. It can be an email, text, what have you. It can be submitted to any agency employee. It doesn't have to go to one particular, the city clerk or whatever. The public has the right to inspect records at any time during the office hours of the agency at no cost. In response to a Public Records Act, the agency has 10 days to tell the requester if they have documents in response that are responsive to the request and whether they're subject to disclosure. If it's a huge request, the agency can indicate to the requester that we need more time, and you can get 14 additional days to indicate to them if you have documents. And if they are subject to disclosure, you don't actually have to make the disclosure within that 24-day period, but you have to tell them when you will make the documents available to them, if in fact you have documents. Further responding to the record request, the agency must make copies promptly available after payment of the cost of duplication. You can deny a request for inspection of copies of exempt records. It has to be in writing. You have to provide the reason of why you're not disclosing the documents. The Public Records Act requires an agency to assist members of the public in formulating their Public Record Act requests and help perhaps narrow down exactly what they're looking for. If there are exempt information, confidential information within a disclosable document, then you can redact the exempt information. So they will get a document that perhaps may be all marked up with blacked out information, but the document itself is otherwise disclosable. And typically, if there's personal information about somebody in a public document, a phone number, a personal address, you can just take your Sharpie and black that out. Burdensome PRA requests. There's a case, fairly recent, coming out of the city of Sebastopol. A lot of, especially for small agencies or cities that get just repeated PRA requests from an individual that just really burdens staff time. Courts are reluctant to impose limitations on the public's access to public records. They're sort of the line or the edge of what is burdensome, what isn't, is where the request requires an agency to search an enormous volume of data for a needle in a haystack, or which compels the production of a huge volume of material. Still pretty subjective standards. An agency is only obliged to disclose public records that can be located within a reasonable effort and cannot be subject to a limitless disclosure obligation. But I think generally courts are pretty reluctant to impose limitations on the disclosure of public records or public record requests. Let's move along to inadvertent disclosures of exempt documents. Case coming out of this city, the Ardone versus City of Los Angeles case, which was a challenge to the city's telephone user tax, I believe. So the plaintiffs at counsel, in addition to discovery, also submitted a Public Records Act request to the city seeking documents related to the tax. The city produced a huge volume of documents, and hidden within that huge volume of documents was a memorandum from the city attorney identifying the city's legal strategy and defenses to the case. Probably the last document you want to disclose. So plaintiffs' counsel now have the document. The city said, "Oop, that was a mistake. We need to get that back." They said, "No, sorry, you've waived your confidentiality of the document by your inadvertent disclosure." The court agreed that the inadvertent disclosure of that document waived the city's attorney-client privilege. This case is also pending before the California Supreme Court. The city has submitted briefs on the issue. Just recently, there is a case that came out in the opposite fashion as that, and that's the Newark Unified School District case for Superior Court, where the court ruled that an inadvertent disclosure of an otherwise privileged document did not waive the privilege, and they ordered that the document be returned to the city of Newark or the Newark Unified School District in that instance. So these cases now reached inconsistent results and will be resolved by the California Supreme Court, hopefully in the not too distant future. Okay, coming down to the end here, violations of the Public Records Act. Any person may sue a local agency to enforce his or her right to records under the Act. A court may review records in camera. That is, the judge will sit in his chamber and review the documents to see if, in fact, they are subject to disclosure or not. If a court finds that an agency's refusal to provide access to a record is not justified, then it must award the challenger plaintiff attorney's fees and cost, which, similar to a Brown Act case, can be quite substantial and in the six-figure range. Also, violations of the Brown Act turn up in the paper every now and then and can be sort of high-profile cases and embarrassing to public entities. And just to wrap up, just to remind you, as I said, most public agency documents are subject to disclosure requirements unless they fall within one of the specified exemptions, and the exemptions are construed narrowly by courts. That is, they want the public's documents and business to be subject to review by the public. So that is the quick walk through the Brown Act and the Public Records Act. Are there any questions before we move on to the next item on your agenda? Okay.
Actually, just wanted to thank you so much for your presentation on both. It was great to get a refresher course. And also, is there going to be a contact number for your office in case things are going to arise here and there as far as reaching out to council that we can access?
There will be an attorney assigned to this commission, if there's not already, who should be able to respond to those type of questions. And if they can't, there's a bunch of other people in the office who can.
Great, thank you.
If you want to contact me, I can make sure that the information is provided to you, and you can reach me at 213-978-7730, and my name is Noreen Vincent.
Are there any other questions? Okay, President Rosendahl, you have 3 items left on the table. You have the discussion and adoption of a regular meeting schedule, or at least your next meeting. You have item number 7, items for future discussion, and you have public comment, and I am aware of 2 public comment cards. Would you like to take the public comment at this time?
Yes.
Maria, will you call the names, please?
We have Mr. Bradley Hertz, and we also have Claire Fox. And we typically give 2 minutes each speaker.
Good evening, Mr. President, Vice Presidents, and members of the Commission. My name is Bradley Hertz of the Sutton Law Firm, and I'm here today representing the AIDS Healthcare Foundation, and we have several volunteer advocates here who've been following the progress of this commission as appointments have been made, and we're all very pleased that this day has arrived. We'd like to thank the City Attorney's Office, City Administrative Officer's Office, and the City Clerk's Office, and all of the council members who chose so wisely in getting such a diverse and experienced group to serve on this commission. We look forward to your work and to being partners in the community with you as we look at LA City healthcare and how it can be improved vis-a-vis the county. And so thank you again.
Go ahead, Ms. Fox.
Okay, great. Good evening, commissioners, and congratulations and welcome. It's so wonderful to be a part of this historic occasion. My name is Claire Fox, and I'm the Executive Director of the Los Angeles Food Policy Council, and we are a nonprofit organization that was created by the City of Los Angeles to work on creating LA as a good food system for everyone. So our vision is that food is healthy, it's affordable, it's accessible, it's sustainable, and it's fair. And I'm really excited to be a partner with you all. It's an exciting time for the Health Commission to come together because the City of LA has been making incredible strides on health policy. The Plan for a Healthy LA just got passed, the Mayor's Sustainable City Plan, the Mobility Plan. Our own good food purchasing policy is something I expect will come your way. This is the city's food procurement policy. The city has committed to buying food that is healthy, humane, sustainable, and fair. So these are all things that I hope will come your way. I really encourage you all to prioritize equity in your work, to uplift those Angelenos who have historically been left out of the process. That's why we're all here, right? That's why we care about this work. So encourage you to continue to keep that perspective of policy, systems, and environmental change, to really prioritize low-income communities, communities of color, where we see the greatest disparities of health. Thank you so much for your service to our city. I really appreciate it.
That concludes and closes public comment. The 2 items you have left, that I do not believe we have any cards for at this time, are items for future discussion or discussion and adoption of at least the next meeting.
Yeah. Does anybody have a suggestion of when we should have our next meeting? I'm open, obviously.
Well, it seems like Monday seems to work for folks. I know that the city clerk did a great job calling everyone to find out when everyone was available. So I would just throw a suggestion out there, maybe the third Monday of the month. And I'm not sure if people want to meet once or twice a month. So that might be something that we want to open up for discussion as well.
For me, but I'm a practicing physician and I have patients scheduled. Thursdays are a better day in the afternoon, so if that could be a consideration. What's your day off?
I prefer Mondays. Sorry.
That's right.
I do too. But I'm not wed to anything. I'm open. But Monday seems to be a good day, at least in the context of my life. But I'm obviously open if another day makes more sense because of your professional life.
We could also alternate. We could do 1 month Mondays and another month Thursdays, but it's up to consensus.
The issue with the Brown Act is that you have to have a regularly scheduled meeting date, time, and place. So
Right, so
I'm not.
Be alternating, does it? I mean, it could alternate. It doesn't have, it can still be regularly scheduled. It's Monday 1 month, and then Thursday the following month, and then Monday, then Thursday. It's still regularly scheduled.
So you'd be keeping to Monday 1 month and then a Thursday the next month?
Yes.
I have to operate on a consistent schedule, my teaching schedule, and I am sensitive to your need to see patients as well too. But I think it would be more productive for us if we have a set day, day of the month, set time. I think we can then calendarize ourselves a lot better into the future.
Thursday evenings, the third Thursday of the month, I have a conflict, so just if that's the cycle. But I think I would prefer one day, whatever day it turns out to be. Mondays seem to be fairly good.
What I'll actually need is a motion in a second.
Well, is there a missing piece of information that the city clerk staff that actually did the scheduling query could provide to show where the 15 folks were at in terms of days of the week initially and then hours secondly?
The initial days were looked at Monday and Thursday.
Would it be at this hour on Mondays?
It would be largely up to you when you wanted the time that you wanted to meet. What we would have to do, because this is the only meeting room that holds 15, we would have to make sure that the chambers are available unless there's an off-site meeting. But if there's off-site meetings, there are additional things that we have to take into consideration. So we would, obviously encourage for this to be the standing location because of the logistical concerns.
I'm fine with the time. I just
It's up to you. Today what occurred was that the budget and finance meetings generally are at 2 o'clock on Mondays, and they're usually up in room 1010 of City Hall. But because they had a joint meeting with the Public Works Committee, that's why originally we were going to meet at 4 o'clock today, but we pushed it to 5. But if you wanted to meet later than that, that is certainly your prerogative as well.
I'm sorry, and one of the things that you might want to consider is that if you work to meet on Thursdays, there will be fewer chances that other committees will be meeting in this room, so there will be greater opportunities for us to have the room to ourselves. That's just something to consider.
not working.
I said I also have a conflicting commissioner meeting on Thursdays as well.
Well, it seems like Thursdays are a bad day, so, I'll adjust my schedule if I need to.
We had asked, originally we had asked for we gave the people the option of 3 different dates, 11, 12, 15, which was last Thursday, today, which is 11, 16, or Wednesday, the 18th. The overwhelming majority was available today, and that's why we ended up choosing Monday. So we didn't know if this was a one-time date or if that's what's on an ongoing basis the best for everyone.
If it is going to be a Monday, then I would prefer later, like we did today, 5.
Yeah. Okay, so are there any objections to the third Monday of the month at 5 o'clock, 5 p.m.?
That would make the next regular meeting on the 21st of December at 5 o'clock.
Just want to make sure that we're okay as far as scheduling. That is the holiday. Well, the holidays are coming those weeks, so I just want to make sure that we're okay with that date.
We could also make it the second Monday. People would prefer that.
I think I prefer the second Monday and just.
It doesn't matter.
Okay.
Unless it's going to fall on a holiday in the next.
The second Monday is December 14th.
Which leads to the obvious question of the initiation of 2016, which is we often have both President's Day and Martin Luther King Day on a Monday in both January and February. Is that the second or?
You can cancel those meetings, or you can hold a special meeting on a different day.
So we have clarification here that in January, the second Monday would not be a conflict. Thank you, Nicole, for using your phone better than me.
It's also, President's Day is also the third Monday.
So Corlin's suggestion of doing it on the second Monday escapes the rescheduling challenge for both January and February.
Okay, so do we have a motion for it to be on the second Monday at 5 o'clock?
So moved.
Do we have a second?
Second.
All in favor?
Aye.
Any opposed? Okay, so the next and the ongoing regularly scheduled meeting will be the second Monday of the month at 5 p.m. here in the council chambers. And then our final item on the agenda for this evening is items that you would like to see on the agenda for future meetings.
I'd like to know what contractual obligations exist between the city and the county for the provision of health services. I mean, I know some of them, but I certainly don't know a complete list. What county functions are carried out that the city has some contractual relationship on?
Okay, so you'd like a discussion item of the contractual obligations.
Right, between, since that's what presumably we're going to be taking a look at, I'd like to know what they all are.
Okay, so the one, we can put that on the agenda, but what we can't provide you is what they are.
Well, I mean, okay, there's a whole range of functions that the county performs. But
Right.
I don't know which ones they have a contractual relationship with the city to
No,
provide.
I understand the issue. The issue is you don't have any staff right now.
Oh, well, that's, well, I was going to ask, I mean, this is supposed to not take any general fund time. And as far as I can tell, we've already used up a certain amount right now. So I was not quite sure how that was going to all be performed. That was a sort of
Right.
preliminary question.
Yes, we can put it. We can put that on the agenda, and then you can discuss at the next meeting how to accomplish.
Okay.
Unless somebody volunteers to look into it.
Okay.
On their time.
Commissioner Histrich, I have a potential amendment to that to, I think, try an accomplishment within the resource constraint, which I think remains the sort of looming challenge for effective functionality and expeditious outcome, right, in 12 months. It seems to me that, at least I'm aware of, both based on the comments of our two public speakers and other information, that there's three city departments that execute or implement various health-related functions in concert with, or perhaps not in concert with, the county. And perhaps our agenda item could be written to request report from specific department staff. And here are three examples that come to my mind. May not directly address what you're saying, so I'll certainly withdraw it and put it up separately. But one is the City Council has adopted a plan for Healthy Los Angeles, which I believe is owned underneath at least primary staffing under the planning department, which is operated in court, the plan is being developed or implemented in coordination with county public health. So we could request a presentation from city planning, which might illuminate some aspects of that. The second one is the Housing Community Investment Department takes steps to support community organizations with covered California enrollment and actual medical care enrollment. We could potentially request a presentation from City HCID to learn about what functions they're performing in concert with county on that. And then the third one is obviously the AIDS Coordinator's Office within the Department of Disability that provides a number of important functions and funding services. We could potentially request presentations from these three city entities that could illuminate a little bit about what we need to know.
That's certainly a good step. The largest healthcare provider within the city is this fire department, and they actually have a relationship to the county's Emergency Medical Services Commission, of which I'm also a member. So I'm not quite sure, but it seems to me that's another area. But that's clearly under the purview of the Fire Commission, and we're not going to co-opt that. But since that was mentioned in some of the documents I received from the CAO's office saying that's one of the commissions, then we need to figure out how that, but you're right. I mean, I think housing actually also has a relationship with the Department of Health Services. There's a program of city housing for folks. Anyway, but those three that you mentioned are a good start, and possibly a few others.
Yeah, I might mention the Department of Aging.
That's right, yeah.
And I don't know that you would have a conflict by asking the fire department specific questions. If you wanted a presentation on a specific area, I don't think there would be a problem with requesting that information from the fire department.
It seems to me we need a framework or a model that kind of defines this umbrella that we're taking on. What is health, or how is this commission going to define health? That Healthy Plan LA that was just released recently is a great, I feel, a great foundational document to work from to identify the various agencies that we could be involved with and can get more information from to come up with some operational definition of what it is that we're trying to do. So I think we need a lot of information first. It seems like we have a lot of work to do, so we have to start with some groundwork.
So piggybacking on that comment, I would like to, just for the business end of the agenda, to have on there the formation of our subcommittees so that we can start to do the sort of real work of the commission. And also, I'd like to invite someone from the county working on the Housing for Health program, which is a program that is housing folks who are homeless and also intersects, interestingly enough, with the fire department and several other city departments.
I'll second that if we need to keep that. It's a great idea.
Would it also be possible to get the information regarding how this commission might be staffed? You had alluded to there was some planning or thoughts regarding how it might be staffed, and I think that might be a good discussion or way of looking at how we're going to get some support to carry out our mission.
Okay.
Would it be possible to get someone to give us a report from My Health LA to kind of go over just the overview of it so we can understand into what the main priorities and focuses are, the objectives?
The My Health LA, that's the Healthy Plan, okay.
No, My Health LA is the county entity that is leading, the county initiative that's leading medical insurance enrollment for what's called the indigent population of Los Angeles County. Healthy Plan LA is an actual city council ordinance that directs planning and other agencies. So So what Commissioner Jack is referring to is a county function.
Okay.
Thank you. Okay, so what we will do at this time, these don't not necessarily require a vote. What we will do is work with the president to formulate an agenda for the next meeting, taking into account all of your suggestions, and we will make available for both you and the public the council file that Patty Huber, who's the Assistant General Manager or Assistant City Administrative Officer, alluded to regarding the staffing plan, so that you have that. All right. If there's no other further comment or questions, we can adjourn the meeting. Oh, yes. Oh, thank you. Thank you, Commission President. On each of your desks, you do have the oath of office that I administered. If I could ask you to sign those documents, and my staff will collect them for you. Oh, Commissioner Shannon did not receive one, Brian. We have a motion and a second to adjourn. So without objection.
It's unanimous.
Okay. So this meeting is adjourned, and thank you all for coming.